This afternoon on a discussion / debate, we'll see, on whether antitrust enforcement has gone too far. We have two truly wonderful and accomplished speakers joining us. First, Mr. Matt Stoller. Mr. Stoller is a director of research at the American Economics Liberties Project. He is author of Simon & Schuster book Goliath, the 100-Year War Between Monopoly, Power, and Democracy, which Business Insider called one of the year's best books on how to rethink capitalism and improve the economy. Mr. Stoller is also a former policy advisor to the Senate Budget Committee. He worked as a member of the Financial Services Committee in the U.S. House of Representatives during the financial crisis. While a staffer, he wrote a provision of law mandating a third-party audit of the Federal Reserve's emergency lending activities. He also helped cut part of a $20 billion subsidy to large financial institutions. His writing has appeared in the Washington Post, New York Times, Fast Company, Foreign Policy, The Guardian, Vice, The American Conservative, and many others. Mr. Stoller writes the monopoly-focused newsletter, Big, with 10,000 subscribers. 10,000 subscribers. Thank you so much for joining us. We also have Mr. D. Bryce Hoffman, who is a partner at Cleary Gottlieb, where he focuses on antitrust enforcement, including merger clearance and conduct investigations, consumer protection litigation enforcement, and other complex commercial litigation. Prior to joining the firm, Mr. Hoffman served as director of the FTC's Bureau of Competition from August 2007 till December of 2019. As director, he was head of the FTC's antitrust enforcement, was responsible for developing bureau policy, supervising all the bureau's investigations and litigation, and conducting high-level relations with other leading antitrust enforcers, including the U.S. Department of Justice Antitrust Division, the Director General for the Competition of the European Commission, and other international enforcers, and state attorneys general, as well as communications with Congress. Bryce also spearheaded the creation of the Bureau of Competition Technology Enforcement Division to monitor competition in U.S. technology markets, investigate potential anti-competitive conduct in those markets, and take enforcement actions when warranted. Thank you so much for joining us as well, Mr. Hoffman. And without further ado, I'll turn it over to Mr. Stoller for his introductory remarks. Thank you.
Yeah. So by the intros, I guess you understand Bruce is a real expert. I'm a fake expert, but I will do my best. So make better jokes also.
Antitrust jokes are hard.
Yeah, I guess so. Okay, so thank you for inviting me. So the topic today is, has antitrust enforcement gone too far? And so I'm a writer, I'm not a lawyer. I largely do kind of businessy reporting. And so I'm going to speak from that perspective. I'll talk a little bit about some of the history of how we have thought about consolidated power and how it relates to the law. But taking the question a different way, not has antitrust gone too far? We could ask it by saying, does America have a monopoly crisis, right? Of private monopolies. And it is actually a really interesting subject. I'm a liberal Democrat. And so, but there is, so what I was gonna say is, please, if you put me in like prison camps, like give me pudding or something that's like, maybe access to an exercise yard, something to look forward to. That was a better joke, and yet no laughter at all. I thought that was pretty good.
It's a serious group of people.
Yeah, no, you guys are, okay, so I'll try to. But it is an area of actual bipartisan continuity, right? So Trump launches the antitrust suits against Facebook and Google in 2020. Biden continued them, actually won the liability phase of the Google search trial, brought a bunch of others. And now it seems like early days yet, but the second Trump administration is not shrinking from at least merger law and some of the other elements of monopolization law. So a few weeks ago, they shocked Wall Street by blocking or challenging a $14 billion acquisition of Juniper Networks by Hewlett Packard. It's not, the details of that are not that important. The fact is they just did it. And that would have been a huge deal 5-10 years ago. Now it's just another Tuesday, right? That's the change that's happened. So why? Well, on one level, we have the obvious stuff. Conservatives think about censorship, deplatforming of Trump in 2021, the collapse of monopolistic firms like Boeing and Intel. There's a real crisis of confidence in an American economy. Ticketmaster. Everybody experiences the Ticketmaster is not only a monopoly that charges high fees or alleged, but can't sell tickets sometimes, right? So there's this lack of a crisis of confidence. But I think to take, move out of the realm of anecdote, more fundamentally, America is no longer a land of small businesses. And it really used to be until the financial crisis of 2008. So here's the Washington Post last week, quote, before the Great Recession, most Americans worked for businesses with fewer than 500 employees. Today, it's reversed with 53% of us working for businesses with 500 or more workers. And the big changes among people who work for companies more than 10,000 workers. Like it's a different country than it was just a few years ago. There's a lot of evidence to support the point. So here's Project 2025. The current data strongly suggests that US corporations are systematically earning far higher profits than they were 25 or 30 years ago, combined with other evidence that large corporations are accounting for an increasing share of revenue and employment. It certainly appears that many large US corporations are earning substantial incumbency rents and have been doing so for at least 15 years, apart from during the depths of the Great Recession that began in 2008. So this dynamic splits the parties in weird ways. On an intellectual level, you have on the Democratic side, you have the former Federal Trade Commission Chair, Lena Khan, who had a lot of important arguments and sort of captured a bunch of the Democratic Party thinking. But Steve Bannon recently called himself a neo-Brandeisian and said Lena Khan should have more power. Sorry, I'm not. I don't.
I'll keep you track.
You keep track.
Yeah.
So meanwhile, this is Jason. I'm going to read a quote from Jason Furman, Obama Council of Economic Advisors. So he was lauding what the Washington Post reported on. He said, this is a favorable development. Big businesses generally pay better, do more training, engage in less wage theft and other abuses, and have more upward mobility, right? So it's an old debate. I'm going to read a quote from Brandeis in 1933 in the Liggett versus Lee case of dissent. He's talking about chain stores, but he could also be, it's basically the big business fight of its time. Chain stores, by furthering the concentration of wealth and of power and by promoting absentee ownership, is thwarting American ideals. It is making impossible equality of opportunity. And I love this line, that it is converting independent tradesmen into clerks, and that it is sapping the resources, the vigor, and the hope of the smaller cities and towns. Now, if you get rid of the old-timey rhythm of that, that's basically the same argument that you could hear today from all sorts of people, right? So what's the case for more antitrust enforcement? Well, antitrust is not the only law that's meant to deal with monopolization and consolidations of power. There's plenty of laws that are arranged around that. You could go into almost any body of law and find elements of that. But Robert Bork understood that antitrust was the tip of the spear. It's the ideological framework for how we interpret a whole bunch of other laws. But let me start with a practical question. How much enforcement has there been? Because if we're going to talk about too much, well, there's been a lot of news reporting about it. I don't know how much you guys have paid attention to it. There's been a lot of upset deal makers on Wall Street, but 99% of mergers still go through without challenge. I doubt 98% of them, they don't even get a second look. And in terms of monopolization, while there has been a dramatic change in enforcement priorities, the actual institutional capacity is really, really low, crazy short of what we need. So there are, I believe, fewer lawyers at the Antitrust Division today than there were in 1979, despite a much bigger economy, much bigger population, much more complicated. Cases take far too long. So there's a lot of monopolization cases, Apple, Meta, Google, Ticketmaster, Amazon, RealPage, so forth. How many of them do you think have come to a conclusion? They've been started over the last 5-6 years, right? Zero, right? The Google case won the remedy phase, or the liability phase, in the remedy phase. They're all going to go on appeal. They're private cases too, but none of them have reached a conclusion. One of them has had a liability phase and a remedy phase is now on appeal. We need about 100 times as much enforcement to address the monopolization crisis, and it needs to go 10 times faster. Okay, so let's go to the why. What, aside from sort of the practical elements. So I'm going to crib from Professor Josh Kleinfeld at George Mason. So there's two ways to make an argument for or against antitrust enforcement. And the first is to situate the argument in a question of utilitarianism, to do lots of cost-benefit analyses on whether it adds more consumer surplus or not. And we can have a debate over that. That's how Robert Bork wanted to debate antitrust law. That's how a lot of the liberals in the 80s, 90s, and 2000s debated it. We can see there are huge problems with how we've enforced antitrust law over the past 40 years. Our fractured defense base can't make enough weapons. Big tech and media conglomerates engage in censorship, spy on users to control American advertising markets and politics. Drug shortages are now pervasive in our hospital sector because of a Soviet-style central planning apparatus in the form of giant purchasers. Farm bankruptcies are pervasive because of market consolidation among agriculture, fertilizer, livestock, and poultry giants. But that debate, the practical debate, is, I think, avoiding the question of what should be of real interest to conservatives and liberals, which is about values. Do we live in a freedom-loving society? One could presumably live in a society where you have golden handcuffs, where one gets to live, earn a nice living if one chooses, and not say anything to offend powerful interests. You guys are going to have the opportunity to live that lifestyle if you want. But is that an American society? Is that the kind of society that we live in? If we want to live in, is that a free society? Now, I'm not a lawyer. I'm a writer. I write about monopolies, and what I notice most of all in conversations I have, I'll be quick, is fear. That's what I hear from business people. If you're an app developer, it's having problems getting your app store, get through the app store. You're afraid of Apple and Google. You don't want to say anything. If you're a farmer, you don't want to anger JBS, Cargill, John Deere. Doctors are afraid of saying anything about United Health Group. I wrote a story about a monopolist in cheerleading, Varsity Brands, and I had cheerleading coaches saying, you have no idea how deep the conspiracy goes, right? It's not the CIA, that's cheerleading, and they're afraid, right? And that is, I have a bunch of quotes historically about how this should not be the way that America operates, and I'll leave those aside. But the point is, these companies are big and powerful, and they have power that they shouldn't have. Maybe right now, they're scared of the Trump administration. But if they keep that power, they will flip, and they will work for whoever they perceive to be having power in operating in their interest. They'll work for the Chinese government. They'll work for Democrats. They'll work for Republicans. It's power that they shouldn't have, and they will misuse. So do we need a bigger FTC, a DOJ, more private rights of action, court procedural reform, state action? The answer is, in my view, generally yes to all of those. But there are many ways to organize the institutional capacity to protect our freedoms, and we shouldn't get lost in process. The real question here is, are we going to live in a land of liberty for the American people to ply their trade, or are we going to live in a land of liberty for the monopolists to control how we do so? And ultimately, without the ability to challenge these dominant entities, we will answer that question in a way that dishonors the society that we've inherited.
All right. Stop. So I have, roughly an hour worth of material that I'll condense to 10 minutes. I could do it by speaking really quickly because as a former high school and college debater, but I'm not going to do that because it would be unintelligible for everybody here. But I'll start by saying this. I think Matt and I probably agree on a lot of what he just said. I think the difference is in diagnosing cause and solution as opposed to identifying the existence of the problem. Right? And I could pick up each of the examples that he gave and talk about it specifically. I would say we actually represent Varsity Brands and defeated those cases in litigation. But I could pick up each of those examples and explain why the issue that
Come on, there were settlements.
The issue they identified is not related to antitrust policy. But I think I'll go at this in a broader way, and we can pick up in Q&A if you wanted. I could talk about any specific examples. What I would say is the issues that Matt described are really a consequence of change in the underlying U.S. economy and in trade policy and other areas like that, and have really little or nothing to do with antitrust enforcement. On the broader question for the debate of whether antitrust enforcement has gone too far, what I would say is it's gone too far in some directions and probably not far enough in others. And to illustrate that, I'm going to make 4 points. First, that the claim that antitrust enforcement has been lax or failed isn't true empirically. 2, that the reforms the Biden administration tried to do largely failed to expand antitrust enforcement. 3, that the things they did that did expand antitrust enforcement are largely harmful to the economy as a whole. But 4, what the Biden administration did missed an opportunity to increase antitrust enforcement in ways that I actually think would be helpful. And I'll try to get through that in my remaining 9 minutes, 8 minutes, whatever it is. Let's start with the facts empirically, what's happened. I think this is actually really important because you have to, in order to understand what a problem is and what the solution for it is, you have to understand where it came from, right? So to start with, it's important to remember that the antitrust philosophy that we had in this country that was the subject of the attack by Lena Khan and folks of that group was the product of a 40-year bipartisan and largely global consensus. So this was not a product of a Republican or Democratic administration. It was multiple administrations over multiple decades who came to the same basic conclusions about how antitrust policy should work. The attack on that consensus really boiled down to 3 points. Point one was there's been an increase in concentration, a loss in competitiveness, and you heard Matt say some of those things. Secondly, there was a decline in enforcement. And third, that there's some inability to litigate successfully. And those things just aren't true. So let's start with concentration. The fact of the matter is, if you look at the US economy on a national level, what you find is over the last 2 decades, there is a very, very slight increase in concentration across large industry measures. But that concentration means that in a typical market, you have at least 10 major competitors, and the 4 largest between them have 50% share or closer to 42% share. So that means that you have, in general, very competitive national markets. And that, by the way, excludes imports, right? So if you include imports, that whole picture changes and becomes even less concentrated. Now, if you look at what we think of as antitrust markets, which are typically smaller, like, for example, when we talk about retail coffee markets, we're not looking nationally. We're looking at what's in like 10 minutes from here, because I'm not going to go further from that for a cup of coffee. And if you look at antitrust markets, what you see is concentration has generally been declining over the last 2 decades, that markets are more competitive at that kind of level. And this is true both in terms of products and geographies. Also, what you find is that concentration has declined most sharply in the most highly concentrated industries. In other words, when I look at industries that are pretty concentrated, what I tend to see is that those industries have had more entry and more competition than the industries that are more fragmented. So what does all this mean? Well, what this is consistent with is national growth by successful firms, right? As opposed to some failure of policy. Think about it this way, a very simple way. I'll go back to coffee. If Starbucks starts from a small store in Seattle and goes nationwide, and you're measuring concentration nationally, you will see an increase in concentration of retail coffee because now I've got a big national brand. But if you look at any given geographic area, what you'll see is Starbucks and Panther Coffee and this coffee and that coffee. And actually what you find is measured at that local level, you typically have more competitive markets than you did 20 years ago. Corporate profits. So Matt specifically mentioned this. The claim is that they've increased as a share of national gross domestic product. That's actually really not true. If you look at the domestic share of corporate profits as a share of US GDP, the most recent in 2020, it was about 10.7%. In 1963, which is right from the era that was heralded as the salad days of antitrust enforcement, it was actually 11.3%. What has changed with corporate profits? US corporate profits have grown dramatically due to overseas profits, not profits gained in the United States. In the United States, the share of corporate profits as a percentage of GDP has actually declined. This is not a failure of US competition policy. It's probably a success of US policy in some ways. Now, you could argue about where are those profits going? Are they coming back to the country? That gets into trade and tax issues, not antitrust issues, but it certainly doesn't support the hypothesis that there's a failure of antitrust. Just really quickly, by pretty much any measure, the US economy has outperformed all other developed economies over the last 25 years. If you just look at our economy, and I should say, Europe is often held out as a standard for what we should do in antitrust enforcement. Now, I don't want to overdraw the causal connection between what's happened in Europe and the US on antitrust relative to the economy, but I'll just note that in the last 20 years, 25 years, the US cumulative GDP growth rate is 34%, whereas the EU is 21%. US labor productivity has grown by 22%, EU zone 5%. US GDP per capita, in 1990, the gap was 16%. Today, it's more than 30%. Recently, there have been articles about how the wealth in England is roughly comparable to Mississippi, not to knock Mississippi, but that's not exactly the standard that you want to be holding out. So this is not evidence that antitrust policy has failed. I would also say in terms of this notion that antitrust agencies don't litigate, the number of merger challenges has risen steadily over time, as has the winning percentage until the Biden administration, which actually got off to a very rough start in litigation, largely recovered, I think, as time went on, but initially did very poorly. But there's just no evidence that the antitrust agencies have been less litigious. In fact, the evidence is they've been more so and more successful in litigating. So what does that suggest? It suggests that there wasn't, or there may have been a problem, but it wasn't the problem that people talked about. So let me turn to my second point, which is what happened with the Biden administration. I'll go through this pretty quickly, but look, the claim from the Biden administration was we need to dramatically increase merger enforcement. What actually happened? Well, mergers increased under the Biden administration. The percentage of mergers that were challenged fell relative to the Trump administration. The total enforcement rate, which is challenge versus filings, declined to historic lows. By the way, the highest enforcement rate in the last 20 years was Trump in 2020 for the FTC and Obama 2016 for the DOJ. Enforcement actions stayed flat under Biden. Criminal enforcement declined significantly. And conduct cases, these are non-merger cases, were basically flat. Well, what did they do? What they did was they made merger process a lot more costly. Now, I could get into infinitely boring detail here, and I won't go into that. But what I will say is, what we have seen is in merger enforcement, instead of stopping mergers, what the administration did was cause the price of mergers to rise. Now, you would think over time that would deter mergers, and I think it would have to. There's just no empirical evidence that actually has happened yet. But you would also want to say, well, why is that a good thing? Why should we make mergers more costly? Remember, and Matt made this point, right? Mergers that get scrutiny are around 2% of the total number of mergers that get filed. So let me just explain that really quickly. In this country, if you do a deal over a certain dollar amount, you have to report to the government under Hart-Scott-Rodino filing, HSR filing. There's about 2,000 to 3,000 of those a year. Historically, about 15% of those got investigated, which means one agency or the other looked at them. And about 2 to 3% got a detailed investigation, and about 1.5% had a remedy imposed. Given that you have, in that case, a 98% false positive rate, why would you increase the cost for 100%? That is bad policy. So where have we not gone far enough? I think where the Biden administration really missed its shot, it took some of these shots, but it hasn't gone far enough, is on single firm monopolization. I'll highlight two areas, and Matt talked about this. I think it's an area we agree on. I think Section 2 of the Sherman Act, which targets monopolization, has suffered from under enforcement, I think, because it's actually very hard to interpret. There's plenty of cases that say nobody knows what this means. No one can tell the difference between hard competition and anti-competitive conduct. These things are true, but that doesn't mean that you can't find good cases. And I think there just haven't been enough. I'll single out two areas. One is a weird body of law has arisen that says somehow when a monopolist engages in torts or misrepresentations, that should get extra protection. Or if a monopolist breaks laws, that somehow should be exempt from antitrust prosecution because it's a violation of law. I think this is literally insane. I don't understand why when a monopolist commits torts or misrepresentations or breaks law that somehow gives it more of a defense than it would have if it just engaged in a breach of contract. But this is a weird strand of the law. The second is the use of intellectual property as both a sword and a shield, where somehow if you engage in anti-competitive conduct using intellectual property, you get a free pass on antitrust. This was heavily pushed by my close friend, Macon Delrahim at the Department of Justice. I think it's a misguided idea, and you see some bad cases coming out of it, like the Qualcomm decision from the Ninth Circuit. And then I think in mergers, I think we haven't paid attention to the right places. The one area where there is clear empirical proof that mergers have been harmful is hospital acquisitions of smaller hospitals and physician groups, and yet there's almost no antitrust enforcement there. Why? One, most of those transactions are below reporting thresholds. And two, many of them end up getting protected by state regulation because of capture of state legislatures by lobbying groups run by the hospitals. And so they immunize them from federal antitrust review. All of this means, I think, that a good, careful approach to antitrust enforcement could go further than it has gone, could increase enforcement, but not in the way that was proposed by the last administration, which, as I said, was largely either ineffectual, or actively harmful.
Rebuttal.
Sure. This time I will time. So thank you for that commentary. So when you get into antitrust, one of the things, I didn't actually start. There we go. There's a sort of weird language that you hear about. So competition, concentration, all become, restraints of trade all get inverted in very strange ways. So first I want to, so Bruce said that they defeated the varsity cases. So I want to sort of read a article here. Judge gives final approval to $82.5 million varsity brand settlement. There's a series of settlements. That's the cheerleading. So, there was a series of procedural elements. I don't want to get into it, but it's just not true what he said. Now I don't like starting out with that. But one of the interesting things that if I were to go through in detail what he went over is that would probably be the only thing that he said that I could definitively say that's not true. The rest of it is a kind of torturing of language. So I'm going to pick one part of it, which is the track record of the Biden administration, which is continuity with the Trump administration. He says it's a record low in terms of merger challenges. Now in 2010, there was a merger of Ticketmaster and Live Nation. And the whole music industry was like, don't do this, okay? But the Obama administration did it. They allowed it. Now, you would think that allowing this merger would be considered, you have a column that says mergers you allow and merger challenges, you would put it in the we allowed the merger column. But that's considered a merger challenge. Why is that? It's because they had a divestment. They said, Live Nation, you have a little piece of software that might compete with Ticketmaster and you have to put it in an independent company. And because they said you're going to put it failed immediately, everybody knew it would fail. But because they did that, technically, in the area of antitrust enforcement, that's a merger challenge. Now, what the Biden administration did is they said, none of that nonsense anymore. We're going to take you to court. Now, the difficult piece in antitrust enforcement is not cutting a deal to allow merging parties to go through or settling cases with powerful people. That's easy. Doing the divestments, which is sort of like the FTC and DOJ were basically investment bankers for a long time. The hard part is pulling the trigger to go into a court and argue before a judge and risk losing. And if you look at what the Biden administration did, that's what they did. And they didn't do it against the little guy. They did it against companies worth tens of billions of dollars, hundreds of billions of dollars. And they did it a lot. 3 or 4 or 5 times more than the Trump administration did. Much more than, I think there was a period during the first Obama term when they didn't bring any challenges for years, especially against powerful companies. The Trump administration did bring challenges into court, but it was for companies like small marine chemicals companies, stuff like that. The Biden administration brought challenges against companies you've heard of, the top of the economy, okay? And they won a lot of them, and they lost some of them, okay? But they tried to reorient the policy. Now, when you hear, instead of taking on that ideological choice directly, what you're hearing is, there's the old Woody Allen joke, the food here is terrible in such small portions, right? That's what you hear. Oh, they didn't do anything, and also it was super costly. Well, you got to pick a lane here. The thing about antitrust, and this is, I think, sort of the problem, and one of the reasons America is so confused is because a lot of these arguments, the arguments about efficiency, are they're manipulated and tortured by people who are paid a lot of money, economists, to say things that are not true. We can all see that factories have moved to China. We know that. But if you actually talk to economists at the time, they would tell you that that's not happening. And they would have all sorts of studies to tell you why that's not the case. And you would hear America has the best economy in the world, and yet our lifespans have been declining since 2015. You can see, I could paint, if you give me $1 billion, I could paint any picture I want. And that's what monopolists have been doing for a long time. You, as lawyers to be, are going to have a choice of entering this world and choosing to embrace this tortured language and work on behalf of the powerful to make America a land that is not free, fundamentally a place where neither conservatives nor liberals can actually experience liberty or you can go in and actually try to figure out what's really going on. Because I can tell you that the people who are scared and talking about the coercive contracts that they are forced to choose. And I could go into Google case, I go into Amazon, I go into any of these cases, and I could explain to you how the monopolization is happening. The independent pharmacist, the independent grocery store, the distributors, even big companies too, they can explain why what's going on is monopolistic and why they can't say anything in public because they are too afraid. I could go into details there. But the point is, this language has been tortured and perverted for a really long time. And one of the reasons that the Biden administration got so much crap over this, right, from Wall Street, not from the traditional conservatives who actually like what's going on, is because they challenged the premise that you should believe your lying eyes and not the economists.
So, yeah, so I'll start by just refuting one factual point and then turn to the bigger picture. The Biden administration did not increase litigation against mergers. It actually brought fewer litigations. And every measure brought less merger enforcement actions, however you choose to count them. Every single observable measure, going to court, winning cases, issuing second requests across the board. The only statistical measure by which the Biden administration exceeded prior administrations was on a category they call abandonments, right? And this is a category where supposedly the merger was abandoned because of antitrust investigation, but there wasn't actually an enforcement action filed. Now, this is a real thing, right? It happens a lot. It is, however, almost impossible to verify. And there is some real statistical questions, like notably, if you look at the Biden administration, this category has a huge jump in the last fiscal year reporting, because prior to that, the statistical enforcement rates were really bad across the board in merger enforcement and the stats the government reports. This one statistical category shot up in the last year. Well, notably, they changed the language they used to describe it, to speak about changing language, which made it a much broader category. We know for sure that some of the deals they counted, such as Amazon, iRobot, Choice Wyndham, failed not because of U.S. antitrust enforcement, but for other reasons, like in Choice Wyndham, they didn't get shareholder votes. And the numbers jumped really strangely. Like, for example, DOJ went from 3 abandoned deals in fiscal year 21, which is 2021 through 2, to 16 in the next fiscal year after they changed the way they counted them. So who knows, right? But when I look at the things you can actually count, like number of second requests, percentage of second requests versus the number of transactions, number of litigations that went to conclusion, you don't see any increase. And in most of those categories, you see slight decreases in enforcement. What does that mean? I don't know. It just means that there wasn't any kind of revolution in enforcement. By the way, you also don't see a decline in the number of mergers. You don't see a decline in the size of mergers. You don't see a decline in mergers proportional to GDP. There's just no objective evidence that there is any meaningful increase in enforcement. On the notion of abandoning consents, I can tell you from personal experience that what actually happened was the Biden administration said, we're not going to sign consents. So they then just told the parties behind the scenes to go fix deals themselves without having an enforceable court order behind it, which the parties happily did. This is great for merging firms. It's horrible government antitrust enforcement because it leaves you with a settlement that's completely unenforceable by the government because there is no track record of it. And in fact, this kind of behavior is illegal for the Justice Department. There's something called the Tunney Act, where DOJ settlements are supposed to get court review and public review, but by using this device, the Biden administration managed to avoid judicial review of their settlements because there was no settlement to be enforced. There was just a wink and nod to the private sector. So let me leave all that aside, though. I think there's a bigger picture point. As I said at the outset, I don't actually disagree about a lot of sort of the big picture economic issues that Matt raised. My argument is a little different. It's that those problems, right? For example, the growth of superstar firms. You mentioned the App Store. Apple's App Store is not a product of antitrust enforcement. It didn't come from mergers. It didn't come from anti-competitive conduct. They just built it. Everybody likes it better. Is it very restrictive? Yes. Is that something people worry about? Yes. But is that a product of antitrust enforcement? Hard to draw that conclusion. Trade problems, jobs moving to China, is that a problem of antitrust enforcement? No. Is it a problem? Absolutely. the concern that I raise is antitrust has become a convenience, right? A way that people can say, hey, the government should step in and fix these problems, which aren't the result of competition policy, right? They're a result of other issues, some positive, like reducing the barriers to information moving quickly across the economy, which tend to favor the growth of large firms. Some negative, like decades of really terrible trade policy, especially towards China, that fail to protect American interests. But using antitrust as a tool to fix those is profoundly misguided, right? It's sort of like if all I've got's a hammer, everything looks like a nail and I'm just going to swing away at it. That produces bad outcomes. Again, I don't want to overdraw the causal link, but I will say Europe has, until recently, had more aggressive antitrust enforcement than the US, and Europe lags the US in essentially every measure of economic growth, technological development, and even at this point, fiscal stability, which is frankly hard to believe, but that's where we are. So look, I identified areas I think antitrust enforcement could be improved. I think those are right. There are probably more. But I think using antitrust as a proxy for problems that have other causes is both wrong and dangerous.
Q&A. Like, yeah, I can start, I guess. I guess for Mr. Stoller, is wondering, do you think the kind of consumer protection standard that has become commonplace in antitrust enforcement, do you think that's a good standard to have, or would you prefer something more kind of lax in terms of going after companies who are big by nature of them being big?
So I think there's just sort of open question about whether there should be a single standard for the antitrust laws. There are multiple laws that were passed at different times for different purposes. And the idea of a standard, the consumer welfare standard, which is not, defined and has many different, meanings. Originally it was just about price, and then we're like, oh, the other things matter according to other than price, quality, innovation. Oh, we can incorporate those into the standard, right? If you just keep redefining it, it's not standard, which is why courts have largely tossed it aside and isn't really used anymore. But the interesting part of it, and I think this gets to Josh Kleinfeld's general approach and general point, which I thought was compelling, is aside from doing what I think conservatives don't like, which is to read something into the statutory text that isn't there just because judges like it, just because economists have said it or moral reformers or whoever. It's sort of I don't know how you can be an originalist or a textualist and just say, oh, these bunch of different laws, we're just going to import language that's not there and use it. But more fundamentally, it's a utilitarian approach to a moral argument in the law. It's a moral Congress set a moral policy saying that competition is important in America and set things like price discrimination is unlawful. And this, the consumer welfare standard was really just a way to read things out of the law that Congress put in there. So I think one of the things that got lost in the discussion between me and Bruce is the question of values. What kind of society do we want to live in? And we had the debate that I started by saying there are two ways to argue it. You can argue it on a kind of technocratic level. Are we living in a society full of bounty and stuff that we can consume? And Bruce said yes, and I said there are some issues there. But the more fundamental question is, are we living in a free society? And that's, you'll notice Bruce didn't even try to attempt to argue about that. The question of fear in the economy. You guys, you can talk to doctors that can't hang a shingle anymore. The pharmacists, it's very hard to be an independent pharmacist anymore. It's very hard to be an independent tradesman. We are moving into a nation of clerks. And we can debate why that is. And Bruce will say things about what's happening. I'll just note on the litigation standard. That's not true because I actually compiled those statistics because nobody compiled statistics about how often the agencies went to court to block mergers. And when I compiled those statistics, it turns out there is a measurable change. And I looked at the statistic because of that. But the errors in what he's saying aside, the question really is about values. Why is there so much fear and anger in our society? And it isn't just antitrust, and I think we both agree on that. There are elements of trade, there are elements of monetary policy. One of the reasons for the huge surge in mergers in 2021 and 2022, the reason is because we had huge bailouts during COVID, and that causes Wall Street to want to engage in mergers. That's really a problem. But we have to think about what kind of society we want to live in. What kind of values underpin what it means to do commerce. And I think if you take something away from this discussion, you have to think about two forms of liberty. Are we talking about liberty for the public, liberty for the citizen, liberty for the business person, the engineer, the farmer, the artist? Or are we talking about liberty for the monopolist and the middleman? Because there is no technocratic way to answer that question. That's a question of values.
So a footnote and then main response. The footnote is there are at least 3 private sources that track merger litigation and other merger enforcement statistics every year and issue regular reports them every year. And the government does too. So the notion that this isn't tracked is just not right. But secondly, in leaving
I mean, they just don't track going to court. They just don't.
They absolutely do. You literally do. There's an entire category from the government that tracks that. The Decker report tracks that. The company report
No,
tracks
I
that.
read the.
Anyway,
No.
like yeah, I can circulate.
As much as as much as you won the varsity.
I can circulate the report. Look, you know as well as I do that people settle cases after you've defeated the main claims for lots of reasons. But in any event,
Give me $80 million
in any-
if you win this debate.
in any event, there are multiple sources that track merger litigation statistics. If you don't believe that, I can send them around afterwards. But leaving that aside, turning to the consumer welfare question which is the question that you actually asked. Look, the consumer welfare standard isn't well understood, right? This is a way to figure out what does this language mean? The antitrust laws are written like constitutional provisions. They're very broad and they're very vague. They say, there shall be no contracts, combinations, or conspiracies in restraint of trade. Monopolization is prohibited. No one ever defines what that means. And then in mergers or acquisitions that are likely substantially to lessen competition are illegal. So that I think this was intentional, right? I think the laws were written very broadly so that they could be informed by ongoing understanding and change and evolve over time to deal with changes in understanding of how the economy worked and changes in philosophy, right? That's all fine. Where did the consumer welfare standard come from? Well, that came from trying to figure out how do we decide if a particular practice is hurting competition or not? And I'll just give you a good example. So when I look at a cartel, and I think it's important to remember that cartels were the dominant form of economic organization in the world for centuries. We called them guilds, right? People had guilds. Guilds restricted price competition. They restricted labor competition. They purportedly maintained quality standards, but they were the ubiquitous form of economic organization. So there's nothing sort of, if you think of that as law school terms, it's not malum in se to have a cartel. People don't think of it as like murdering somebody. It doesn't seem bad inherently, actually. So you have to tell people this is illegal and don't do it. But if you're starting from scratch, there's a really valid question about a cartel, which is this. How should I decide when I'm counting the effect of the cartel, whose benefit do I count? Because the cartel might be really good for the cartelists, right? They may make more money. They can pay their workers more. They can invest more in whatever they're doing in R&D or labor security or building better factories or just, taking home more money and building bigger houses. Who knows, right? But they do really well. On the other hand, the people who are trying to buy stuff from them take it on the chin, right? Because they're having to buy stuff that's more expensive. There's less of it. It's worse quality. There's less innovation. So the consumer welfare standard arose out of trying to figure out when we're looking at a merger, when we're looking at a practice, whether it's a cartel or a unilateral practice, and we're counting the economic effects, who do we count, right? And you could say we're going to use total welfare. This has been proposed, like we'll measure the total effect of the practice on society and we'll condemn it if it's negative and we'll say it's okay if it's positive. But that might result in saying, well, the cartel is fine, right? Because the net effect is positive and we decided not to do that. So we have consumer welfare as an alternative to total welfare. There is another possibility. Right. The other possibility is using these much more amorphous standards. So if I go back to Brandeis, for example, at that time, people would say, well, antitrust is to protect the freedom of the worthy businessman to build up his livelihood or things like that. The trouble with this sort of analysis by verbal formulation is it ended up becoming completely standardless. right? Because anyone could articulate a basis on which you could use antitrust to protect whatever interests they happen to like. And the consequence of that was you had antitrust law, which really was just a tool of the government to go after whoever the government didn't like at that particular time. And it was impossible to predict the results of antitrust review ahead of time. So you couldn't meter your behavior to antitrust law until I think it was Justice Harlan famously observed, the only consistency I find in our cases is the government always wins, right? Because there was no standard. So the development of this was not, and I wouldn't sit here and tell you, oh, consumer welfare is the best standard of all time. I think it's actually quite hard to find. I think it's kind of slippery and has real problems. I would just say it has been better than any other alternative anyone has been able to articulate in terms of being relatively objective, relatively predictable, and relatively understandable. Is it perfect? Absolutely not. But given the alternatives, it's better than anything anyone has come up with yet.
Thank you so much for coming. I have a follow-up question on what you said regarding corporations and hospitals. And you said that there were state laws that immunized the corporations from being held accountable by the federal government. Can you expand a little bit more on that? Like how exactly are states shielding corporations from federal antitrust?
Sure, it's a little weird, right? You think it's a
Yeah.
supremacy clause, but
Right.
there's a doctrine in antitrust called the state action doctrine.
Mhm.
This arose out of a set of Supreme Court cases where basically it originally involved activities of the state itself. And so the Supreme Court said the antitrust laws were not meant to govern activities of state governments. You know, they weren't intended to override federalism. So if a state government did something anti-competitive, you can't use the antitrust laws against it. That evolved into this notion that private companies doing anti-competitive things are okay. That's outside the scope of federal antitrust law if a state has essentially blessed that policy. So and there's a very technical test, like if it's purely private companies doing it, is it the product of a clearly articulated state policy to displace competition with regulation, and was it actively supervised by the state? If it's a subordinate state organization, like say a municipal government, it just has to be the product of a clearly articulated state policy to displace competition, and the state doesn't have to actively supervise. So it's kind of complicated, but one of the things that has happened as a consequence of this is like hospitals are quite good. You can also find this like auto dealers. There's lots of people who are very good at lobbying state governments. And they tend to go and get state governments to do things like a lot of states have organizations that do reviews of hospital mergers, and they'll actually issue, they're called certificates of public advantage or certificates of necessity that will say this merger has been reviewed and approved by the state. And courts have generally said that prevents a federal antitrust challenge to that merger. The FTC has for years been going to state legislatures and saying, stop doing this. Like when you do this, we can show that it's very harmful. Like patients pay more, insurance companies pay more, health outcomes worsen. You're ending up with all these monopoly hospitals in small towns for the most part. And the outcomes are sort of unambiguously bad. But the FTC's campaign against this has largely failed. Now the FTC actually did carry on a long effort. When I was there, I served in the government in also 2001, around that period. And one of the things we had then was what we called the Hospital Merger Retrospective Project. The government in the 1990s lost, I think, 10 straight hospital merger cases. We studied this, we came up with a new way to attack hospital mergers, and we succeeded after that in defeating a whole bunch of hospital mergers in court. But we can only take them to court if they haven't been blessed by the state this way. And so hospitals are not dumb, and they have moved their efforts into getting state immunity from antitrust challenge. And I think it's a real problem.
Yeah.
To what extent do you think antitrust enforcement should be a function of economic conditions of the day? For example, if you're in a developing country, you might want to under-enforce so that you get to these numbers of high GDP growth, economic growth, fast growth, big business. Whereas if, the Europeans would say, we have already passed that stage of development that we don't care anymore about adding that marginal level of labor productivity. We now care about other things. So to what extent do you think antitrust enforcement should be a function of the economic stage that a society is in?
So I'm interested in Master this, but I would say it should not be, right? And I think the idea that having like cartels or state champions is going to actually help you advance in any way where the benefits outweigh the harms is just wrong. And in fact, you will do better as a society if you focus on, now again, this has to be smart antitrust enforcement. If I destroy incentives to innovate and don't allow companies to grow, that's going to be bad. But if I have antitrust enforcement that preserves competition so that firms aren't cartels, that I don't have mergers to monopoly, that I don't have a monopolized economy, I'm going to grow faster and better, and I will more equitably distribute the wealth, right? Than if I try to do it by allowing cartels or allowing, for example, government monopolies or things like that, which just almost never work.
Yeah, I actually I agree with that. I also would take issue with the premise of your question, which is that consolidation generates more labor productivity by investing. I think it's the opposite. It's the competition. If you look at why America industrialized, it was because it was a competitive economy versus being controlled in many other areas in the world.
Totally agree with that.
All right.
Yeah.
One word.
Is it okay if I do two in one kind of? I actually have one for each of you, if that's okay. Let's start with, is it Mr. Hoffman?
Yeah.
Yeah. Could you talk a little bit more? You said monopolization, like Section 2 has been under enforced. Do you think like new legislation is the right way? Are there cases in the past that you take particular issue with? Like, how can we go about rectifying that?
Sure. I think legislation is really hard. I mean, here's the problem with Section 2. Right? Section 2 prohibits monopolization. And what we understand that to mean in the US is we don't go after companies for succeeding. If you're big, fine. What we look at is how did you get big and how are you staying big? So it's a conduct offense, right? Not a status offense. The problem in Section 2 has always been how do we tell good from bad conduct? Right? Because it's not enough, for example, that I want to hurt my competitors. We actually kind of want all competitors to want to hurt their rivals. We don't want them to be cozy and chummy with each other. So when I have a lot of evidence that company A wanted to hurt its rivals, that doesn't actually help me very much in figuring out if what it did was anti-competitive. So this issue of, or another example, like suppose I just invent a better product. Everybody comes and gets it. Now I get a 90% market share. We don't want to stop that. On the other hand, the old sort of classic traditional case that people would use, or the example people would use is, we don't want the company, instead of building a better product, to go blow up its rival's factory, right? So you can intuitively understand the difference. It's just, it turns out to be really difficult to actually implement. When you look at conduct by firms that have really large market shares, it's very challenging to say, okay, well, this conduct was anti-competitive, this conduct was not, sorting those out. And so there has been a quest for the last 30 years to articulate, standards that you could apply that would better sort those things out. One of the things that has happened is this sort of barnacle-like growth of a lot of specific rules and tests, like, for example, the one I mentioned, which has made it extremely difficult to challenge courts or misrepresentations by monopolists as being anti-competitive conduct, right? There's just courts have stated some rules for those that I think are just insane. I mean, to me, like a tort is the perfect example of conduct that has no redeeming pro-competitive value. And so I would say, okay, that clearly could be anti-competitive conduct. Now my question is just what was its effect on competition? But I can tell you that's not where the law is. Like under the law, I have to jump through a series of hoops to be able, even though the monopolist is out there like publishing false claims about its rivals, I got to jump through all these hoops to be able to go after that. And I think that's just crazy.
And then my one for Mr. Stoller, it seems like one of Mr. Hoffman's complaints was the tip of the spear, it's being overutilized, right? Just this idea of an excessively broad hammer. How would you respond to the idea that maybe some of these just aren't necessarily supposed to be antitrust suits?
So just in terms of Section 2, because I think it's an interesting question. I mean, Section 2 was, I don't think it's very hard. There's some edge cases, but we know that when a company is big enough to deplatform the former president of the United States, it's too powerful, right? We can all admit that. There's a bunch of and maybe you do a haircut is a little too much, but Brandeis gave a metaphor once where he said, sometimes you don't know how, like he was talking about a lawyer advising their client, and he was like, how close is too close to the edge of the cliff? He's like, stand on the very, very, very edge, maybe like an inch from the edge. He's like, just tell them to stand 10 feet from the edge. So you know they're safe. And that's true with monopolies. In general, monopolies don't add very much. Usually they're inefficient, bad at what they do, mostly Boeing type companies. That's what happens. That's why the Chinese DeepSeek beat all of our big tech companies, because they're not very good at things anymore. So I don't think it's very hard to figure out what is, if you have 90% share and you're like, I want to hurt my competitors, that's pretty much enough. Used to be enough. And the reason we're in an economy of monopolies is it's no longer enough. But the way that you restore Section 2 is the way that the Biden administration and the Trump administration did it, which is you bring Section 2 cases. They brought cases against Google. They brought cases against Apple, against Facebook, against Amazon, against Ticketmaster, against RealPage. And the result is that attorneys and the plaintiffs' bar are starting to bring those cases, and law firms are developing practices around bringing those cases. So you've seen Michael Jordan, of all people, sued NASCAR over monopolization. A company called Particle Health sued a company called Epic Systems over electronic medical records. Epic Games, a different Epic, is suing Google over app stores and won that liability case, to your point on apps. So there's a lot of, Section 2 is coming back. And court judges are reading it differently because they see that we live in a monopolized, they read the paper too. They see our wonderful healthcare system, and how it works. So just in terms of responding, I mean, look, every case, and we could go through indeed, like the antitrust bar just likes to make broad brush and say, oh, they had no rhyme or reason. They were just making things up. And it's like, do you really believe that from 1890 until they discovered the consumer welfare standard, that antitrust is completely random and completely socially determined and was just completely vibes based and whoever they wanted? I mean, of course not. That's like a ridiculous premise. And, but it's conventional wisdom in the antitrust bar because they put out lots of stuff that is just nonsense. Another nonsensical argument is, oh, the laws are so vague and so hard to interpret their constitutional statutes. That's just not true. Read the Robinson-Patman Act. It is very detailed. And what they did is they said, oh, we don't like this. We're not going to enforce it anymore. And they developed a consensus that they just didn't have to enforce this law on the books. And they come out and they say, well, everybody knows that that's not, yeah, it's a law. Yeah, it's a congressional statute, but not really. And then they made it vibes based and then said, well, if you believe that, you should enforce this statute, well, you're just a fool. You're silly. You don't know what you're talking about. And that is, I think, the general approach is just kind of like this sneer. And so we could go through specific cases. Almost every case that the Biden administration brought, frankly, every case, they found evidence of price hikes. They usually found evidence of excessive market share. Sometimes they found evidence of, someone that owned a distribution outlet and also owned either a sales part, a retail outlet or a production arm, foreclosing rivals from getting in. I mean, just classic meat and potatoes, unlawful behavior that we've seen for 120 years. You go back 500 years and find similar stuff. This is not like, it's not like they just sort of invented it and said, we don't like this stuff. Bork had this line where he talked about how it's just the sheriff comes out and just whips someone with a pistol to show their boss. That's how he framed antitrust law. It was completely dishonest. It was just not the way that they did things. We had a rule of law. A bunch of conservatives and leftists didn't like it because they liked big institutions. The right liked it because they thought businessmen were awesome. And the left liked it because they thought, well, if we consolidate power in the hands of a few, that's a way to socialism. And it was just a values-based determination. But the process arguments are largely vague, vibes-based garbage.
I think that's all the time we have today. Thank you so much to our